Hello, everybody, and welcome to the Kathleen Scott podcast. I'm here with my partner, Gabe Roberts, and we're talking about some exciting news in the labor and employment law field. One of the things I love about this practice is that every day something new happens. And something new recently happened this week in the case of Ames versus Ohio Department of Youth Services. This is the United States Supreme Court opinion that considered whether or not Marlene Ames, who is a heterosexual female, had a viable claim for sexual orientation discrimination based on what happened to her during her employment. So, Gabe, you want to give us a little bit of the background, then we can dive into the juicy nuggets and the details?
Yeah, we can do that. So, Marlene Ames, she worked for the Ohio Department of Youth Services, and without getting into all the details of the various roles she applied for, didn't apply for, essentially, she is alleged that she was passed over for one position within the organization in favor of a lesbian employee, and then was also demoted from her current role, or as they put in the case, she accepted a demotion to a lower role, and there was a gay male was hired to replace her in the role. So she brought a claim against her employer under Title VII, which prohibits discrimination based upon various factors, including sexual orientation, and said that essentially the company had discriminated against her based on being straight, and that had she been lesbian or gay or any other sexual orientation beyond straight, that she would have either been promoted or kept her role.
And so it's interesting because we sometimes refer to these cases as, quote, reverse discrimination cases, right? But really, Title VII and in our state, the Florida Civil Rights Act, don't really speak to, all forms of discrimination are illegal. So the court was wrestling with this concept they had in the Sixth Circuit about what is the burden a person has to show in order to have a discrimination claim in a quote unquote like reverse discrimination case. So what did the court find?
Yeah, I mean, they basically said that, like you said there, right? Title VII says discrimination is discrimination regardless of your sexual orientation in this context here. And it's not so much that they said reverse discrimination is possible. I mean, that's been the law all along. They basically said that you can't have heightened requirements for somebody who is part of a, quote unquote majority group in order for them to bring a claim under Title VII.
It's kind of interesting because they use this word background circumstances. So it's almost like it's exactly like the Sixth Circuit was applying a certain rule of law that said if you're going to have a claim for discrimination, you have to show that there's sort of a background of the employer having a sort of a preference towards individuals either outside of your racial group or outside of your sexual orientation group. So, and here they dismissed her case saying that there was no evidence, what I like to call evidence of animosity. There was no pattern of history of discriminating against people who were straight. And so the Supreme Court reversed and said, we're going to look at this, we're going to treat all people equally, and that whether or not you're gay or straight, the law applies to you the same, and you can be discriminated against equally. So I guess is this a victory? Is this a victory?
I don't know. I don't think it's a victory for anybody, if I'm being honest. I mean, it's, depending on your views on things, maybe you can try to spin it as some sort of victory of if you believe that reverse discrimination is a thing. I don't know. But it's not. It's a victory for Miss Ames in the sense that her case will now go back down to the lower court in order to continue. She still has to prove her actual case, right? This was as we know, when we're dealing with discrimination claims, there's 3 stages to the case. And in this case here, the first stage, where she has to prove her initial baseline or prima facie case, as we like to call it when we want to sound fancy, they said that she couldn't do that in this case because she didn't have those background characteristics. But now the case will go back down, and let's say she can prove that, well, the company still gets to present whatever they want to consider a legitimate, non-discriminatory reason, and she has to prove that's pretextual. So she has not won this case. Her case just continues, and whether this is a dramatic change in the law for members of quote-unquote majority groups, I don't know that I see it that way. It's kind of the Supreme Court saying, hey, here's what the law is, and we just don't think you should do anything more.
So Constantia Jackson, writing for the majority of the court, is she our newest Supreme Court justice? I think that's right.
Correct. Yes, newest justice. That says a lot that she got to write this opinion. Not that it's a big deal to short the opinion. I mean, she's a great jurist and it's a good opinion. But this was a unanimous Supreme Court, so all 9 justices agreed with this decision, and Ketanji Brown Jackson, as the newest justice on the court, she got assigned the opinion. And the way Supreme Courts, the way the opinions are are assigned by the Chief Justice is the justices get together, they vote on how they want to rule, and then whatever block gets the majority, so here it's 9-0, so all 9 justices were in the majority, it goes in order of seniority as far as who gets to write the opinion. So the Chief Justice gets first dibs, and then he passes, and then it would go to Justice Thomas, and then Alito, and it would go down the line based on seniority. So when the justice with the least seniority is writing a unanimous opinion, that kind of tells you this is an opinion without much sort of, I don't want to say without much substance, but it's opinion that the court wasn't too concerned about.
Interesting. There's some great language in here, and one of the quotes I'm going to read is right from the opinion that says, as a textual matter, Title VII's disparate treatment provision draws no distinction between the majority group plaintiffs and minority group plaintiffs. And just to kind of break that down, as labor and employment lawyers, it's often that our clients are in the minority group who are claiming, disparate treatment or discrimination against, being treated differently than somebody like outside of their racial group or their sexual orientation or gender or whatnot. And
well, just because to jump in there, I mean, I think it's because it normally is the minority group that's being discriminated against, right? Like that's right. The unspoken thing is the reason why minority groups bring discrimination claims is because it's minority groups that get discriminated against.
But maybe this is good for men. I feel like, isn't there a whole not that you can speak for men everywhere, but isn't there a whole view
I think we're fine. I don't think we need anything else. We're good.
But this does highlight the point that whether you're a male or female, you're equally as protected under the law against discrimination on the basis of sex. So, in that way, it's an interesting opinion, I think, because we don't. I feel like we should move away from calling things like reverse discrimination, because discrimination on its face is discrimination regardless who the victim is.
Yeah, exactly, and that's it's kind of every once in a while you'll get these opinions from the court where they're basically just saying, hey, we're just reminding everybody this is what the law is. We're not saying anything dramatic or grand or changing anything. It's just this is a quick 5-page opinion of just, hey, here's some great language for every lawyer to cite in their summary judgment motions now, because you can cite to a 2025 Supreme Court opinion telling you what Title VII says, right? It's straightforward.
It is, but then there's a little edge in there. Maybe it's, I don't know, I don't want to call it an Easter egg because it's not hidden, but there's, Justice Thomas concurs with the opinion, but he cites to something that if you're not a practitioner in the labor and employment world might not seem like a big deal, but he talks about like undoing the legal framework, the framework, it's called the McDonnell-Douglas framework, that has been the basis of how we analyze discrimination cases for the last, since 1964 or whatever the year the opinion is, 1973.
73, yeah. Okay.
73, yeah. So he basically says we should throw McDonnell-Douglas out the window and adopt a different framework called the convincing mosaic. I thought that was particularly interesting.
Yeah, it is, right? I mean, this is what I was talking about earlier with those 3 stages, right? McDonnell-Douglas established step 1, employee proves prima facie case that, I belong to a certain class and an employment decision was made that was motivated by that class. Step 2, once you prove that, employer has to present whatever they want to say is a legitimate, non-discriminatory reason. Step 3 now goes back to you, the employee, to prove that reason is pretextual. And that's been the law of the land for a long time. For most people practicing labor and employment law, we don't know a world in which that's not how you prove a discrimination case. And so it's interesting for Thomas to say, hey, I agree with this. And he's very clever in his language. And Justice Thomas will do this. He can't help himself but concur sometimes to say what he thinks should happen in the future. And so he's like, I'm not saying that this is the case to overturn McDonnell-Douglas, but if there's any, aspiring lawyers out there with cases that are primed for summary judgment, if you want to argue in your summary judgment motion that McDonnell-Douglas should be overturned and then get a district court judge to say, no, that's the law of the land and appeal that, well, Justice Thomas, I'm here. I'm waiting for that case because I think when that case comes to me, let's get rid of this.
Yeah, it's fascinating. And so there's sort of like another burden of proof, but I will say, having practiced for 27 years now, the McDonnell-Douglas standard often is a burden for people who are bringing a claim, right? Because it's kind of a hard threshold. It's easy to show you're part of a protected category, not so easy to show that others outside of your protected class were treated more favorably. I mean, you might see it and observe it, but proving it is a very different thing. And so abandoning that for maybe a little bit more of a looser, for lack of a better word, called the convincing mosaic, which is, I think, what they're advocating for, if I'm reading the concurrence correctly, a new type of way of looking, not so new, but adopting a different type of legal framework to analyze these cases. Yeah, I mean, I don't know they use that language, right? But that's essentially what they're saying is you just look at the entire situation here, and do you think that this person's race, age, sex, religion, whatever it is, do you think it was a motivating factor in the decision? And if so, that's probably illegal under Title VII. I
I can't believe I'm saying this, but I really like the way Justice Thomas looks, particularly at the pretext argument, and he makes the point is like, there will be cases where an employee can't prove that something was pretextual, but that doesn't mean they weren't discriminated against. And if that's what McDonnell Douglas says, then McDonnell Douglas goes against the language of Title VII.
Right, and sometimes cases will fail because a person can't identify what we call as a comparator, right? Like somebody in the identical group as them who's treated favorably. But we can all think of examples where someone's being clearly discriminated against, but may not have like an identical person in their job to be like, well, look, that person is treated better than me, and they would lose their case because of that, factual anomaly where they didn't have that. And so I think what he's saying that, at least as I read it, seems like that would alleviate those concerns.
Yeah, I mean, he is, at least ostensibly, if you read what he's saying there, he is trying to make it so that it is easier to present claims of discrimination under Title VII. And I mean, who knows where this is coming from, right? Justice Thomas, prior to being on the Supreme Court or being a judge, he was in charge of the EEOC, way back when. I mean, quite famously, considering some of the things he did when he was in charge of the EEOC. But who knows if this is something he's been stewing on because of that past experience. There were briefs filed by some employee-sided organizations who are advocating for employee rights, filed briefs basically saying, hey, we should get rid of McDonnell Douglas, and a lot of what Justice Thomas said was taking language from those companies, and so, or those companies from those organizations. And so there's a push for this, and it's interesting to see Justice Thomas to kind of adopt that and say, yeah, I think we should just, Title VII says what it says, let's just do that. We don't need to have all these frameworks.
Well, you said something really important there. Title VII says what it says. And so if we can just kind of geek out for a minute on constitutional law, yeah. I think, it was something I definitely picked up on in really one of the first sentences of the opinion by Justice Jackson, where she was basically saying it's textual, mm-hmm. right? So there's been a shift in the court to really adopt and make rulings based on the actual language of a statute and not try to draw too many distinctions or too many, inferences from the language of a statute. That's called textualism, right, for context here, right? And so this idea that the Supreme Court is basically saying Title VII prevents discrimination on the basis of race, color, or gender. It doesn't say it only protects white people, it just says race. It doesn't say it only protects women, it says gender. And so textualism is this concept that the Supreme Court's only going to look at the language of the statute and not go beyond that. And usually, in my experience, that has not been to the benefit of the aggrieved worker, mm-hmm. but we are seeing sort of a shift in how that is kind of becoming helpful, really, to workers' rights.
Yeah, exactly. I mean, there's a whole sort of, there's a cottage industry in academia in the legal field that's sort of coming up around this idea of like progressive textualism, right? There's a lot of law professors out there that have started writing on this, particularly because the current court is very textualist heavy, but also very conservative leaning, right? And so there's a lot of folks out there doing good research who are trying to say, hey, we can have both progressivism, right? We can help people, we can help individuals, we can do what the law is meant to do, but also it's textualist to do that, as opposed to situations where, McDonnell Douglas, it is the law of the land and has not yet been overruled, so it still should be applied. But that is a judge-made concept that the Supreme Court decided, hey, Title VII says this, and here's how we think you should apply that, as opposed to just Title VII says this, and this is what it means.
Yeah, I think we'll have to tell our good friend Eric, who just presented on this topic, that it turns out he was right. Yeah, exactly. I mean, there's a lot of other little Easter eggs in the opinion that are not so positive, right? There is, I bring this up because we did that episode recently regarding DEI and how there's a lot of positives and benefits to DEI. There's also a footnote from Justice Thomas where he says, hey, by the way, also DEI is bad, and the reason why we need to make Title VII easier is because DEI is causing discrimination in the workplace, and so therefore, his a lot of what he says is good, but maybe it's not coming necessarily from the position that we would want to from a more progressive leaning side. I mean, who knows? At the end of the day, it is what the law is, and it can be used to help your client no matter what their leanings are.
Thank you so much for tuning in to the Cathleen Scott podcast. We hope this was fun and informative. We'll catch you on the next one. You can find us online at scottlawteam.com or floridalaborlawyer.com. Thank you for joining.